from here. O God of creation, direct our noble course, guide our leaders right, help our youth the truth to know, in love and honesty to grow, and living just and true. Great lofty heights attain to build a nation where peace and justice shall reign. Amen.
Amen.
So, having said that, I want to respectfully introduce my panelists. I have the panelists here 100%. That shows the seriousness and importance of the discussion we're going to go on with today. Let me start with recognizing and welcoming to the platform His Excellency Governor Rotimi Akeredolu, SN, the Executive Governor, like I've gotten leave to say so, Executive Governor of Ondo State, former President of the Bar, a distinguished barman, anytime, any day. So we call on him. He will leave every other thing to attend to the bar, which is quite important for all of us to emulate that whatever position you get to, should be responsible and responsive to the bar.
Huge pleasure.
Thank
you. Huge pleasure. Thank you.
Well, I'll proceed again to introduce our own recently retired Justice of the Supreme Court. I'm sure if you have not come across those judgments that make you read the law report, if you have not come across Justice Roosevelt, then something would have been wrong. This is a judge I like reading about anytime, any day. I followed him from his days at the High Court all the way through. But today we have him, and he's going to weigh in heavily as our keynote speaker on this point, based on which we will take it to the different branches and departments. Please join me in welcoming Justice Bode Roosevelt, retired Justice of the Supreme Court, to the platform. My Lord, you're welcome.
Thank you very much.
Thank you, sir. And I proceed, not actually in any particular order, but these are distinguished senior advocates of Nigeria who have made their marks in different ways. Household name, Mr. Joseph Daudu, SN, former president of the bar. I don't know what we will talk about in the legal profession in Nigeria without remembering JB Daudu. I prefer calling him JB Daudu. That's what comes on every day, even as we relate with him. A distinguished lawyer by excellence. Produced lawyers in his family, trained lawyers, worked to maintain standards, was chairman of the disciplinary committee of the bar, was chairman in many. Today, those experience, those capacity will be brought to bear as we discuss the issue of expedited order. Mr. JB Daudu, SN, you're welcome.
He's muted. JB, you are muted.
Okay, I move on.
Thank you very much.
Okay, JB.
Yeah, thank you, sir. I have a lady and a gentleman. Let me not call the lady last. So let me. In a male-dominated profession, you will imagine what it takes to get there. In the course of coming up here, it's been wonderful, making suggestions, giving background advice and all that. Mr. SN, you're welcome. And then we have the Prince Latif Fagbemi, all-round guru. But I don't know of any serious election petition in this country that is not there. So that all those experiences will come to bear. Having welcomed everyone,
Thank you.
just to say that I believe that well, distinguished members of the profession, and this will help our audience to understand this vexed issue of ex parte orders and what they've done and what they are doing and what they will likely do to every one of us. I will, before we get there, yield the platform to the chairman of Spidel and then the president of the bar, Mr. Lumidapata, to make their brief interventions. Then we will look at the few ground rules and then we get to the serious business. Meanwhile, thank you panelists for being here. Meanwhile, thank you Nigerians for hooking up and for us to discuss this very important issue. So I will call on Mr. Mondo Nyekachi now to make his brief intervention. President and Chairman of Spidel, Mr. Obani.
The moderator, I want to thank you for the elaborate introductory remark, especially on issue of protocol. So you have actually established a proper protocol. So it will be repetition for me to go through all these best hands we have assembled for this particular webinar. But I want to say this, I want to welcome everyone to this first webinar by the section, by the Spidel, MBA Spidel. It is a very important webinar on a matter of very of public interest. As we are aware, the current resurgence of conflicting and contradictory ex parte orders from across the country have created a disquiet in the system to the extent that concerns were expressed by both the leadership of the bar and the bench on how to tackle the ugly incidents. The Chief Justice of Nigeria, Honorable Justice Tanko Muhammad, did invite the chief judges of the various states where those bizarre orders emanated from, and has followed it up by issuance of queries to the judges concerned by the NJC as reported in the papers. The NBA on his own part, through the president, I think has set up a three-man panel to look into the issue of those abuse of court process by our colleagues. These measures so far are evidence of the fact that these happenings in our judicial sector is clearly not appropriate and palatable. More so when members of the public are raising alarm that the judiciary has become complicit with politicians to truncate our political system. Everyone should be worried by the allegation. And secondly, on the strong and indictive perception by the members of the public who ordinarily should have confidence on our judicial system. The section of Public Interest and Development Law have quickly organized this webinar on this very important issue and have assembled the best hands from both the bar and bench to critically examine the subject matter. I am sure that the legal profession will be the great beneficiary of what will actually emanate from this intellectual discourse. Without much ado, ladies and gentlemen, I welcome everyone to this important national discourse on administration of justice with regards to conflicting ex parte orders from courts of coordinate jurisdiction. So once again, thank you and you are welcome.
Thank you, MOU. That's brilliant. I will move on quickly and then invite the president of Nigerian Bar Association, an amiable gentleman, Mr. Lumida Bata, to...
I think the moderator is muted. The moderator is muted.
We are hearing the moderator. All right, so...
not very clearly.
Not very clearly. He has to be a bit louder.
Yes.
Please, because comments. I know it might take time. Can you join me? So it's not easy for me to ask you to do that. That's you have to call it on a webinar. Make his presentation. Try to just mute. Yeah, we are just waiting for Mr. Louis Dakbata, to the president of Nigerian Bar Association, to hook up and then make his comments as we proceed. All right, while we wait for the technical part to be true, let me move on to invite my Lord Justice Bodero's Bible, CON, to make his intervention. I've been seeing comments on the chat box. Let me assure everyone that the recording of this session will be available to Nigerians and anyone who will be interested. The lead speaker, or the Justice Revival, will be speaking for 25 minutes, so that he can give us a thorough overview of what we're talking about, ex parte orders, the judge's perspective. He was a practitioner too. He's also an experience, and his experience even from the agency point of view, an overview, so that we are at home on the same page on this all-important topic. I'm not a fan of the social media, but I once opened to one of the platforms and I saw where a cartoon that depicts the sorry state of the use of ex parte order, where a judge was saying years and age. And then it calls to mind the use of ex parte orders with respect to the chairmanship of the People's Democratic Party and many other instances, like the governorship in Anambra, governorship issues in Anambra State. There's so much confusion, there's so much worry. My Lord Justice Bodero's Bible, this is a field, a turf you are used to and you know too well. Please help us navigate through these murky waters. What are your thoughts? What are your perspectives about this vexed issue of ex parte orders? Thank you, my Lord. Can we have my Lord begin?
Yeah.
I hope I can hear my Lord.
Do you hear me now? Do you hear me?
I can hear you, sir.
My Lord, we can hear you.
I can be heard now.
Yes, my lord.
Yes, my lord.
We can hear you.
Right.
We can hear you.
I'll just give a brief background. The following should be considered before the grant of these ex parte orders and injunctions. One, the court should grant an ex parte or interim injunction if irreparable or serious mischief will result if it is refused. Two, if satisfied that the delay caused by proceeding in the ordinary way might entail irreparable or serious mischief, the court may make a temporary order ex parte upon such terms as it thinks fit. Three, it must be, hello? I go on?
Yes, my lord, go on. We're hearing you, sir.
Yes,
my lord.
Yeah, it must be an exceptional case, which is serious and unjust. Four, it should last for a short time, 5 to 7 days, and the judge will do well to state it. 5, unnecessary adjournments should not be granted to beneficiaries of ex parte orders. And 6, an ex parte injunction will generally be granted only after a writ of summons, that is the originating process, has been issued. The only exception is if the circumstances of the case are very urgent. Now, judges and lawyers know the guidelines very well. Then why is there a resurgence of ex parte orders? There is always a resurgence of ex parte orders during the period to a run-up to an election. Primaries are held. They are hotly contested. The stakes are too high. A case in point are the recently concluded primaries in Anambra State. The primaries were held to enable the political parties select their candidates for the gubernatorial elections due in November 2021. All manner of applications were filed in court. Ex parte injunctions were indiscriminately granted. There was even a case where applications to set aside results of primaries were heard out of jurisdiction of Anambra State in another state. All this simply because the stakes are too high in election matters. What occurs in the courts by the filing of all manner of actions is an abuse of court process. In People's Democratic Party, PDP versus Sheriff, 2017, Supreme Court. This case was a case where over 10 suits were filed in court, some in Lagos, some in Port Harcourt. The issue was really for the control of the party. Conflicting orders were made by different judges. In that case, I wrote the lead judgment. I said that the stakes are very high in political matters. So if allowed, political office seekers will not hesitate to file multiplicity of suits on the same subject matter, hoping to get a favorable judgment from one court or the other. Their quest for this includes forum shopping. End of quote. How can this annoying practice be stopped? In the same case, I said, heads of court must by now be aware of this trend and stop this annoying practice of assigning cases on the same subject matter to different judges, who very likely would render conflicting decisions, ending up making the judiciary a laughing stock, end of quote. Trial judges must also be on the lookout and refrain from proceeding with any case when aware that his brother judge is handling a similar matter. After primaries are held by a party and results announced, there will always be disputes as to who won the primaries. 2, who was not allowed to contest. 3, who did not contest but won. Many actions are filed in court before different judges to resolve the above. We then start reading and seeing conflicting orders. The resurgence of ex parte orders will be a thing of the past. if chief judges who have the responsibility to assign cases to judges ensure that where matters involving the same parties and the same claims are raised contemporaneously in 2 or more courts, it is desirable and in the interest of justice that these matters should be heard by only one of these courts. This also applies to a judge who ought to be aware that a similar case filed before him is also before another judge. He should send the case back to the chief judge for assignment to the judge who was first assigned such a case. This approach, if adopted by the chief judges and judges, will stop or prevent the real possibility of conflicting decisions in respect of one and the same subject matter. Once again, issues common to both matters should be heard and determined in only one court. Broadly speaking, all that I've been saying applies to conflicting orders generally, and more particularly to conflicting ex parte orders. Now, sanctions. In the 1990s, when Honorable Justice Weiss was the Chief Justice of Nigeria and chairman of the NJC, his lordship set up the Assure panel. This panel's main agenda was to sanction judges who fell short of what was required of them. Quite a number of judges were removed from office for the indiscriminate grant of ex parte orders. After the Assure panel's report was presented to government, the NJC continued recommending judges for removal, and they were removed from office for the indiscriminate grant of ex parte orders, which invariably resulted in conflicting orders. This was the period when judges were heard to say that the fear of the NJC is the beginning of wisdom. Judges who fall short of what is expected of them, especially those who grant ex parte orders indiscriminately, were always reported to the NJC. Similarly, legal practitioners who make it a practice to file suits outside jurisdiction or to obtain ex parte orders knowing fully well that a similar order had already been obtained but not favorable to him, has clearly infringed the rules of professional conduct and should be sanctioned by the judge before whom he appears or reported to the disciplinary council of the bar. So these ex parte orders and conflicting orders and ex parte injunctions are nothing new. They have been with us, and we always hear of them, see them once it is an election year or once an election is about to be held. Thank you, Mr. Chairman. I hope you heard me.
I don't know where the moderator is. We are not seeing him. Moderator, are you there? Paul Ananaba, Prof, are you there?
The moderator has not gone anywhere, Mr. Bani. I'm here. I just wanted his lordship to land clearly.
Okay.
Thank you, my lord. You have done exactly what we are looking at. You've done it, and we are proud of it, of your presentation. We will get to more of all this. But before we proceed further, the president of the bar, Mr. Olumide Apata, is came in mid when my lord was making presentations, and we will want our own president, who has worked very closely with us and has not been quiet with this ugly development. Let's hear him. Please make welcome our president, Mr. Olumide Apata, as he makes his comments. Then we'll continue. Mr.
Thank you, Leonard. Thank you, Leonard Silk. I'm most grateful. My Lord, the Honorable Justice Bodiro's rival, my apologies to you and to the other panelists. I was on another, this is the time or the era of Zoom calls. I was on another call that overshot its time schedule, and I apologize most sincerely, my Lord, and Your Excellency and the other speakers. Firstly, let me thank the section on public interest and development law for putting together what is a very, very timely intervention with regard to a matter that I would say is existential. It is a threat to our profession. It is a threat to our judiciary if this particular matter of conflicting court orders. And I must commend the chairman of the section, Dr. Monday Obani, and his team for putting this together. I am also most grateful to my Lord for his presentation, which I listened to with rapt attention. And I'm looking forward to the intervention from the panelists, which include His Excellency Arakuni Akeredolu, Senior Advocate of Nigeria. I see Latifa Gbemi and SAN, and of course, past President Daudu is also with us. If I have not mentioned the other names, please forgive me. But indeed, as Professor Ananaba has mentioned, we are, as the Nigeria Bar Association is extremely, extremely worried by this state of affairs. I don't think it is necessary for me to repeat what we have experienced in the last couple of weeks, except for me to try to depict to you the deep sense of shame I have felt personally with regard to all the goings on and how we have been called out. We have been called out by judges. We have been called out by Nigerians. The bar has been called out. The bench has been called out because it would appear to be the consensus opinion that the legal profession and the judiciary are intent upon destroying the democracy that has been so hardly, so hard fought and hard won. I don't think that is the position. I don't think that represents the generality of the attitudes of the Nigerian, the lawyers and the judges who are doing a good job. But there are many amongst us who are complicit. There are many amongst us who are partisan or party to this dragging of the name of our profession in the mud. So I think it's important that we interrogate these issues as truthfully as we can. I think it's important that we cut to the chase and we actually identify the areas where we need to deal with this issue. Personally, I think it is the absence of sanctions that makes it possible for some of the players who are involved. The absence of sanctions or the belief that there are no sanctions in our system, which is why on the part of the NBA, we have set up a small committee to look into this matter, led by Dr. Ajibade SAN. And I must again reiterate that in the event that it is found that our members are indeed responsible for this show of shame, those members will definitely be made to face the music. And I'm hopeful that the steps taken by my Lord, the Chief Justice of Nigeria so far through the NJC would also yield results, because it is my belief that if our members and if the judges also know that there are sanctions and there are consequences for actions, that they will indeed, they will sit up and do the right thing. Ladies, distinguished gentlemen, my lords, learned senior advocates, my past president, J.B. Daudu, Your Excellency, I would not want to stand in the way of what I think will be a very engaging conversation. But again, I just want to thank Spidel for putting this together. I will definitely be here to listen to the exchange and take on board whatever recommendations come out of this program. And you have my assurances that we shall implement with alacrity. Because like I said, it is an existential issue. Our profession is threatened, our judiciary is threatened by the acts of very few people, very few people. Thank you very much. Back to you, Professor Ananaba.
Before Ananaba, thank you, Mr. President. I'm your past president too. Thanks, Excellency. I'm not your past president.
That's the problem with wearing too many hats, Your Excellency. You are wearing too many hats.
I'm past president, not His Excellency. I'm not His Excellency.
Past President Arakuri, sir. You're most welcome, sir.
I'm not His Excellency. Thank you.
Thank you, sir.
Thank you. Thank you. That's what the comradeship at the bar is. And I'm happy that our past president and governor has just shown that how we correct ourselves, in a friendly and loving manner. Thank you, Mr. President Olumide Akpata. Let me take it from there. There were two major points Mr. Akpata raised. in this brief speech that I want to hook on to. He said, yes, the CJN is doing something, taking some steps, and is in agreement with that. That's fine. But beyond that, he now said that he's been inundated from various quarters with the fact that, oh, people are saying it is a legal profession that is trying to scuttle or scuttling democracy and all that. And I think it's a good point to look in the direction of our past president, Governor Akeredolu SN, who is in the best position to talk from the political point and to talk from the bar. Is it actually the politicians that are trying to destabilize the sanctity of the bar and trying to use that as an excuse to do their political destabilization of the democracy? Or is it the profession itself that is yielding to being a tool in this regard? So please, let me have the singular honor and privilege to call on our past president, distinguished past president, Governor Arakure Rotimi Akeredolu, SN, to speak on this point. Thank you, Mr. Governor.
Thank you so much. Thank you so much, Paul. My Lord, I must pay my respect to you. I hope you are enjoying your well-deserved retirement. I greet you and pay my respect to you. And Mr. President of the bar and my co-panelists, I pay my respect to all of you. I hope I'm being heard loud and clear. Well, now that Paul has started with me, I was looking at that. It was going to be JP Daudu to start, but because I've strayed into this, they call it a profession, but this vocation of politics, I've strayed into it. I'm here just on a tour of duty. I'll be back with you, so there will be no reference to me as a politician very soon when I come back. But I'm here now. There's no way I can run away from it. I must say, for me as a person, I've always looked at this issue of ex parte as whether you are a politician or you are not. A litigant has the right to bring up anything to any lawyer. Is the lawyer that has a duty to advise his client whether or not what you have is frivolous. But where lawyers have failed, we must take responsibility for it. Every politician will want to take advantage. I mean, I always say this, people who know me very well, I always refer to fella on many things. Inside police station, then they take chance. Everywhere, everybody wants to take chance. So a politician will want to take chance. But it's for you. If you have your name, you must do something. As my Lord rightly said in the introductory remarks, there's use for ex parte order, but there's an abuse. Because of the use to which you can put ex parte order, we will not say we'll throw it away. But people abuse it, no doubt. And I believe that one of the fundamental things that we need to correct is this jurisdiction of Federal High Court. The Court of Appeal, if a matter emanates from Akure, you know that you cannot go beyond Court of Appeal Akure. You can't go and file your appeal in Enugu or in any other place. You have to file in Court of Appeal Akure. And courts don't have extraterritorial jurisdiction. A matter is here in Akure. You now go to Federal High Court in Abuja. Most of them will entertain it, And the question is this: I believe the time has come for the Federal Court to define its jurisdiction in a way in which you don't go beyond where you are located. Because they had come up in some years back to say, as a Federal Court, it's the jurisdiction is federal, the whole country. So you have matters in Akure, they will go to Abuja. You have matters here, they want to go to Maiduguri because they say it's Federal Court. No, Federal Court decision should be defined. That's one point I want us, it must be defined to say that if you are situated in Akure, you are the only one that has decision on matters coming from Akure. It doesn't have to, it cannot go to Abuja. This is one of the problems we are having. So people take advantage of this because the Federal Court says that, oh, the decision is federal. How? How can the decision be federal? So they go to Abuja, 5 matters that is in Akure. So, but for me, as I said, politicians want to take chance. We, as lawyers, have a duty. The court has a duty. A judge has a duty. So, because at the end of the day, I'm sure that by the time we get to before the disciplinary council of the bar, you will say that, look, a lawyer can argue, this is my knowledge of the law, that's how it carries me, I feel I can file it. So you file actions, you lose. So if you file for ex parte application, that's how far it carries you, that's your knowledge. It is the judiciary that must now be better equipped to let the lawyer know that what he's doing is wrong, and by that, by extension, his application or his action file is struck out. You can do that to a lawyer once or twice. I remember a judge in Ibadan has an approach. You bring all this frivolous application, he looks at you argue, you say, look, after we have argued, he will not only address you, he will say to your client, look, you don't have a lawyer yet. I'm dismissing your case. You are going to look for a lawyer. He will dismiss it because it's a frivolous thing. It will hit the lawyer immediately. That means if you are not careful, before you find another client, you take time. He's told you to your face and to your face that, look, you are not a good lawyer. So I don't see any reason why judges must not come up now in matters of this nature and put their feet. They are the one, they are in control of their court totally, as we all say in law. They are the master of that court. Anybody can bring useless application, it's for you to strike it out. But if like my Lord said, somebody comes with brings a prayer before a court, he loses and now goes to another court. That can be said, that is an abuse. And in that instance, then the lawyer can be reported or file an action against him before the disciplinary council. He can be disciplined. But a lawyer filing an action for the first time, thinking he's right, is for the judge to say he's wrong and throw him away. It's because some lawyers believe they are right. Lawyers believe that Federal Court now has jurisdiction over all matters, and they will take their matter to Federal Court in Abuja in particular. That's why Federal Court in Abuja handles a lot of matters that are not from Abuja. They believe they have jurisdiction. So this judicial matter must be settled so that we don't get conflicting orders from Niger, from Plateau, from this on the same matter, because people take advantage of it. So for me, I blame more lawyers and not necessarily politicians. Politicians, if they want, by the time they have their money, they want to file any action, it's for you. You can advise your client, this action is frivolous. I cannot put my name to it. JB is here, Lati is here, and I know that Justina too is here. All of us have parties all together. We will know ourselves. I know that there are cases that Lati have refused. There are many cases that JB will not handle, and Justina too. So that is how it's supposed to be. But there are lawyers, I won't say they are hungry, but there are lawyers today, bring any case, you pay your money, he's filing the action, you will be the one to draft the process for him. He will go and file. That's all. And just put his stamp, what do you call it now? Seal. and file. So we have to discourage that, but politicians who want to take advantage. It is for us in this profession to rise up to make sure that we do the right thing. Thank you. We're not hearing you, Ananabao.
Thank you, Your Excellency.
Okay.
That is a master's work. You have acted as a master in the field. I know I encountered you somewhere along the line, in some of these workers, and I know that you are a distinguished lawyer with finance, and that is still playing out even as you are a governor.
Thank you, sir.
I took out some points from what you have just said, Your Excellency, and I'm sure you are going to come back again when the heat increases in this discussion and to do the usual thing. Jurisdiction of the Federal High Court. I'm worried as a practitioner that we are still talking about the jurisdiction of Federal High Court today, all the way down from Bronick Motors and Wema Bank, MP and Aluminium and all those states of Ocean and Pan Atlantic. We are still talking about jurisdiction of Federal High Court today. That's sad. And judges must now rise up to look at these frivolous applications and deal with them properly, and along with the lawyers and the litigants. Going from you, sir, I read that some degree of discipline should come to the profession, both at the bench and at the bar. So it is a safe point for me to turn to Mr. J.B. Daudu as realizing that he's a former president of the bar, and beyond that, he's chaired the disciplinary committee of the bar, in a committee that will have also distinguished judges, and so he has a bit of all what we are talking about. Mr. J.B. Daudu, tell us, what do you see and what do you think we should do, with a lot emphasis on how do we begin this discipline issue that everybody is talking about? Thank you.
Thank you very much, my Leonard Brothers, Chairman. Please first confirm whether you can hear me very well.
We can hear you.
We're hearing you loud and clear, sir.
We're hearing you.
Thank you very much. My Lord, the keynote speaker, the Honorable Justice Bode Rosvival, has dealt with the topic in his usual characteristic clarity, and the issues therefrom cogently articulated. His Excellency, my brother, past president before me, Akiti Baba, as I call him, has also given a very, very sensitive perspective to the matter, which is the issue of the almost limitless jurisdiction of the Federal High Court. After my paper, I will crave the indulgence of the chairman just to make one or two points on what His Excellency has said on the matter, because it needs, it's clearly one of those areas that needs a better understanding for all of the bar. My mandate is to discuss this erudite dissertation with emphasis on the culpability of members of the bar and to an extent the bench in the procurement and grant of this genre of black market orders, which ultimately achieve nothing other than obfuscate the democratic process and above all, ridicule the legal profession. This is the topic that has been given to me, and it includes but is not limited to the prescribed professional and statutory measures available against both legal practitioners and perhaps judges who are found culpable for the indiscretions that has led to our topic for discussion. And I'll just briefly identify what these topics are so that we know. One is the arbitrary issuance of ex parte order. The arbitrary issuance of ex parte as if they are commodities available in the open market for easy purchase. Two, forum shopping for favorable judgments, and in most instances, obtained extraterritorially from jurisdictions other than where the cause of action arose, thereby eroding from the court any modicum of legal authority to grant sale. That's where you go from, say, Akure, and you go to Maiduguri to seek an order governing the internal issues of a political party in Ondo State. Maybe that's an example. Three, using the medium of indiscreet and indiscriminate ex parte orders to grant substantive reliefs. That is, you challenge the seat of the office of the chairman of a party, and by way of ex parte order, you secure a declaration that his continued stay as chairman is null and void, which in our profession is anathema, because you still have the substantive suit to deal with. The scope of this discourse includes not only in drawing attention to the deleterious effects of these identified vices attributable to the beneficiaries, A, the political class, B, the procurers, who are members of the bar, that is legal practitioners, and C, the facilitators, who are the judicial officers that grant the orders, high court judges, or those who uphold and approve at senior appellate levels, that is the Court of Appeal and Supreme Court, of the grant of these orders. Because of the rampancy of these acts of misconduct and the brazenness attached to the execution, it is imperative that very clear language is employed to condemn this grave transgression of all that the law and justice hold dear and precious. In addition, very stringent punishments of a deterrent nature ought to be agreed upon and scrupulously applied by the gatekeepers of the two branches of the profession, that is to wit, the National Judicial Council for the judges and the Legal Practitioners Disciplinary Committee for legal practitioners without exception. Now I come to the main discussion. It is safe to proceed on the premise that the foregoing acts as described not only pollute the justice and judicial system, that is the streams of justice, but are a danger to our democracy. Time will not allow us to thoroughly examine the negative implications of these vices, but it is undeniable that they cause incalculable harm to our democratic and judicial institutions. The best way of appreciating the conundrum or the dilemma these acts of misconduct places or puts counsel, court, and the public in is to approach them from the legal axiom. I've just picked an axiom and a maxim that the lawyer is a minister or co-minister in the temple of justice. Now, what is the temple of justice? The basic understanding of the axiom, temple of justice, is that the hallowed sanctuary from which justice is dispensed, for which justice is dispensed. Who are the beneficiaries of justice in this regard? These are the people and governments of the Federal Republic of Nigeria and all who benefit from the legal system. This is because justice is a priceless and indeed holy commodity created by God Almighty for order and harmony to exist between human beings and the rest of the world. Now, applying the maxim to the matter at hand, the principle that lawyers are ministers in the temple of justice is anchored on the ability of those who serve in the temple of justice to keep the streams of justice pure and unpolluted. The effect of this phrase is that both lawyers and judges are co-ministers in the temple of justice. Therefore, none of them can or ought to exhibit bad behavior. Where a legal practitioner knowingly advises his client to seek ex parte order when he knows that the circumstances do not envisage contemplate or support such an application, or when counsel engages in forum shopping by going to a court totally lacking in territorial or even subject matter jurisdiction, or one with jurisdiction but recruited to achieve a substantive end through ex parte means. These conducts and their legion, because there are different examples and different variants, as I call it, not only pollute the system, but also amount to a breach of the rules of professional conduct for legal practitioners, 2007. I have referred to some of the rules. I won't read all, but I'll just refer to the main one so that we know that some of the things lawyers take for granted are actually and indeed things that can remove their wig and gown from their head and bodies. So the applicable rules that are close to these issues are Rule 1, 15, 24, 30, 34, and 50, which apply to these variants of misconduct above. I'll just take like 2 or 3. Please permit me, Mr. Chairman. 1, a lawyer shall uphold and observe the rule of law, promote and foster the cause of justice, maintain a high standard of professional conduct, and shall not engage in any conflict which is unbecoming of a legal practitioner. Now, 15.2, it says, in his representation of a client, a lawyer may refuse to aid or participate in conduct that he believes to be unlawful, even though there is some support for an argument that the conduct is legal. That's something like His Excellency was saying. In his representation of his client, too, the lawyer shall keep strictly within the law, notwithstanding any contrary instruction by his client. And if his client insists on a breach of the lawyer shall withdraw his service. B, use his best endeavors to restrain and prevent his client from committing misconduct or breach of the law, with particular reference to judicial officers, witnesses, and litigants. And if the client persists in his action or conduct, the lawyer shall terminate the relationship. So one cannot say that it is because it is carte blanche rule, you must bound to accept a brief. No, you are not. If a brief falls within special circumstances, why you should not accept it, you are duty bound to reject it and send the client back. 24.2, it is the duty of every lawyer on his own responsibility to decide what cases he will bring into court for the plaintiff and what cases he will contest in court for the defendant. And is not absolved from bringing questionable action or arguing questionable advice on the ground that is only following his client's instruction. So that at the end of the day, the liability and the punishment will be solely that of the lawyer. He cannot say, I was overwhelmed by my client. 24.3, a lawyer shall not conduct a civil case or make defense in a civil case when he knows or ought reasonably to know that is intended merely to harass or injure the opposite party or to work oppression or wrong. These are some of the minefields that we stray into. And Rule 10 of 24, which is, no, Rule 30 A lawyer is an officer of the court. That's exactly what I'm saying. And accordingly, he shall not do any act or conduct himself in any manner that may obstruct, delay, or adversely affect the administration of justice. And Rule 34, which says that, that's the last one, that a lawyer shall not do anything or conduct himself in such a way as to give the impression or allow the impression to be created that his act or conduct is calculated to gain or has the appearance of gaining special personal consideration or favor from the judge. Some lawyers go to various forums or fora under the pretext and having represented to them that the judge is my friend. And therefore they travel from one end of the country to the other, going to put pressure on perhaps call favors, which they think they are owed. Now we go to the disciplinary and penal sanctions against lawyers and judges for misconduct. Start with legal practice. Where there is a complaint based on any of the identified variants of misconduct above, and other variants identified in the keynote speech, the legal practitioner is liable to be tried by his peers in the legal practitioner's disciplinary committee. I emphasize the venue for such disciplinary proceedings or action as the legal practitioner's disciplinary committee and not the legal practitioner's privileges committee. As the extant statute, the Legal Practitioners Act 1975, as amended, exclusively vests the jurisdiction to discipline a lawyer for professional misconduct on the LPDC and on no other body. Granted that the LPPC, that is the Privileges Committee, can take away its preferment, that is the rank of silk, given in the form of the prestigious and exalted rank of Senior Advocate of Nigeria. But if the withdrawal of the rank is hinged on professional misconduct, traceable to the rules of professional conduct for legal practitioners, then it is only the LPDC and no other body under the law that can make a finding or determination that the legal practitioner is liable for infamous conduct, professional misconduct, however so called. It is only after the concerned legal practitioner has been found culpable that he can be sanctioned with either disbarment, suspension, or admonition. After the LPDC has finished its work, in the case of suspension or admonition, as a punishment for the affected legal practitioner, who is also a senior advocate by way of example, and the LPPC is not satisfied in respect of that senior advocate of Nigeria, then the punishment is compatible. And the LPPC is not satisfied that the punishment for that senior advocate is compatible with the continuous wearing of the rank, even after the period of suspension has been served. It may and has the prerogative to withdraw the rank, whether permanently or for a specified period of time. There is no concurrent or coordinate jurisdiction between the Legal Practitioners Disciplinary Committee and the Legal Practitioners Privileges Committee in respect of matters of professional misconduct by a legal practitioner. For the avoidance of doubt, only the LPDC and the Supreme Court, through the Office of the Chief Justice of Nigeria, can exercise disciplinary powers over an erring legal practitioner accused of running afoul of the rules of professional ethics for legal practitioners 2007. See section 9 to 12 of the Legal Practitioners Act. Now, there are so many variants of conduct by legal practitioners which, like my Lord we keep kaput, amounts to abuse of process. One of them is asking either the Court of Appeal or the Supreme Court to review his judgment after it is functus official. There are so many others, but I think others will deal with that when they present their paper. Now, as it relates to the judicial officer, on the part of the judge, the National Judicial Council is by the 1999 Constitution, as amended, empowered to investigate and punish him accordingly, in accordance with the provisions of the NGC regulations in force at the given time. It is the gravity of the misconduct or its frequency or its rampancy that will determine which sanction will be passed, either outright dismissal, removal from office, suspension, or even a warning. In the event that the misconduct involves allegations of bribery, the participants may also be subjected to criminal prosecution and punishment in a court of law. Also, a judge before whom a frivolous application is brought has the powers to cite counsel who filed such an action or application for professional misconduct. Thankfully, the bottleneck of subjecting petitions of misconduct against lawyers to the internal investigation process has been removed by the LPDC, new LPDC rules. So it moves faster now, and litigants really have no excuse to complain that some of the complaints are being filtered in the NBA when that is not the case. Therefore, any person who is aggrieved by any misconduct of counsel can directly file an application before the LPDC for prompt and immediate determination. Another aspect of misconduct which requires further elucidation is on the question of what happens to the politician who is the catalyst of misconduct. Nobody has spoken about how he is punished. We know how the lawyer can be punished, how the judge can be sanctioned, but what of the politician? How do we discourage the political class from interference with both the bar and the bench? The politician is beyond or outside the professional disciplinary control, jurisdiction, or regulation mechanism of both the bar and the bench. Therefore, all that can be done, apart from imposing very stiff punishment on the lawyer and the judge found wanting, or making themselves available for political manipulation, such that when similar situations seems impending in the future, these lawyers and judges will be deterred from willingly burning their own fingers. This assumes that the reputation and prestige enjoyed by lawyers and judges means a lot to them, such that whatever may be the consideration or inducement offered by the politician who is desperate to achieve his own ends, these lawyers and judges would be concerned about the odium and disrepute that will follow the sanctions that they are likely to get from their colleagues. However, the fact that the disciplinary institutions of the legal practice pay lip service to the issue of discipline is the reason why offenders are emboldened to continue in their various acts of misconduct. Most offenders escape punishment mostly because they have of support in high places. Everybody has a godfather in the system, so they think, and they are goaded into taking the action to say, don't worry, do it, nothing will happen. This is how deeply infiltrated the judicial system and legal system have become. or penetrated by political elements. It is a sad development of which we must purge ourselves immediately. This is just to say that this is not to say that the affected politicians cannot be punished. They may be indemnified in punitive costs by appellate courts who are usually called upon and who swiftly reverse the injustice arising from the unlawfully or mischievously obtained ex parte order. Therefore, costs can be used as a vehicle to dissuade the desperate politician from going about seeking order. But I know at times money is not the objective, is not a problem when they get to that level. And where another means of putting some sanction on the politician party to the proceedings is that if that political office holder is a member of the executive or the legislature, he may be taken before the Code of Conduct Tribunal for perversion of the course of justice or any other appropriate offense in the circumstance. So for that, you look at the court schedule of the Constitution that deals with offenses that can be taken against the legislators or the members of the executive who are political office holders. Another factor which encourages this kind of professional and judicial misconduct from the bar and lower superior courts is, I say it with respect, the mixed signals received from the appellate courts in similar circumstances. Examples abound, but I'll just give like one or two. Let us take a look at the recent development in pre-election cases where legal practitioners approach willing judges outside territorial jurisdiction of the course of action to obtain or procure ex parte orders, some call it black market orders, which in most cases resolve substantive disputes in the absence of the defendants. This type of misconduct and the participants have been roundly condemned by all stakeholders, including the Honorable Chief Justice of Nigeria. One would have thought that now that such an issue is on the front burner, all lawyers and courts will avoid similar situations or actions. However, recently, in another development, appeal emanating from the decision of the Federal High Court sitting in Port Harcourt found its way directly from Port Harcourt to Abuja, division of the Court of Appeal, notwithstanding the fact that there is a division of the Court of Appeal in Port Harcourt. Now, if a High Court hears a matter, delivers judgment, the law is that save in exceptional cases wherein reasons must be given, only the appellate division which oversees the jurisdiction of that High Court should hear the appeal. If not, why do we have 16 divisions of the Court of Appeal when every sensitive case finds its way to Abuja? The act of transporting appeals across Nigeria to Abuja is tantamount, in my humble view, to foreign shopping and amounts to an assault on the confidence reposed on the judiciary. This may be unwitting or it may be a product of convenience, but it is better to go through the difficulty of moving to the jurisdiction than to move the case to Abuja. The apex court, that is also the Supreme Court, must also, like Caesar's wife Calpurnia, be above board. We may think these problems are limited to lower superior courts, but at times, superior appellate courts also must look carefully at some of the body language coming from them so that lower courts do not misinterpret some of these things. Like I said, Supreme Court must also, like Caesar's wife, be above board. Its decisions and other judicial actions or steps must be devoid of multiple interpretations and unpredictability. Now, the ability to predict the position of the Supreme Court lies in the court's resoluteness to stand firm on the side of the principles of stare decisis, not adherent to the principles of judicial precedent, as the Supreme Court has been accused on one or two occasions, has led, unfortunately, to the emerging pattern of conflicting decisions on the same point or issue by the court in different cases. Examples abound, but the scope of this discourse will not allow, the expansion of this irregularity. Now, these features of preferential treatment inherent in the cases where precedent is not followed are signposts of breaches of the rules of judicial accountability, which is a strong barometer in the measurement of the independence and impartiality of courts. So before concluding, I will just advert to the reference by His Excellency Arbitrary on the jurisdiction of the Federal High Court. He says that it should be defined. I agree. It is defined, but new jurisdictions vested on the Federal High Court now give room to forum shoppers. Now, if you look at the provisions of the section, I think 258 of the Constitution on the election cases and 87.9, I think to always confuse them. They've created new vistas for these courts to interfere or to intervene in pre-election matters. Lawyers, in their characteristic expansiveness, have now interpreted it to mean that where INEC is headquartered in Abuja, you need to come to Abuja to file an action which you should have filed in Akure and served in Akure. So it is the latitude and the expansive interpretation that is being given to such new areas that bring about this seeming lack of clarity in the scope of the jurisdiction of the Federal High Court. At times, where suits are limited to the interpretation and operation of the Constitution, most of the agencies that are at times alleged to be in breach of the provisions of the Constitution are high-powered committees and commissions and agencies that are located in Abuja. As soon as counsel sees that, he heads to Abuja. One, it enhances his fee to be filing out of jurisdiction. And two, it helps him to avoid maybe the courts where he thinks his governor has total domination over. So those are some of the things that make it appear as if the jurisdiction of the Federal High Court is not properly defined. But I agree with His Excellency that we must make the rules tighter so that it is much more predictable. I conclude on this note. The type of justice that proceeds from the temple of justice ought to be justice that is not only clearly done, but seen to be done, and manifestly done too. The perception of corruption on the judiciary, in my humble view, is worse than even the act of corruption itself. Hence, while the Court of Appeal may have good reasons to hear appeals before certain panels and certain divisions of the court, and I dare say there are times very good reasons, the expertise of the personnel, the integrity of the personnel, cause them to move matters from one area to the other. But the court must be conscious of the fact that it is a territorial court itself and must not believe that justice can only be served in a location other than where the case was not only first had, but should be had in appeal. In other words, you can move the justices who want to hear the case to that location and let them hear the matter, so long as their safety is not in doubt. Forum shopping in both trial and appellate matters questions or brings about questions of the motives of superior courts, which should not be allowed to hinder the course of justice. That is, and can influence, now this is the catch, can influence lower courts to follow suit as precedent or even bad practice. A lower court misunderstanding or not having the full details why an appellate court has taken one or two steps may say, oh, yeah, well, these courts have, our big brothers are doing this, we too can do it. That is why it has been stated earlier in this discourse that appellate courts should be wary of sending mixed signals to lower courts, as those mixed signals become the prelude for some of the corrupt practice at the lower bench. Furthermore, when trying to remove a mischief, anything closely associated with the mischief must be avoided by those on whom judicial accountability lies. Therefore, if appellate courts do not frown against forum shopping, it will be difficult, if not impossible, to punish lower court judges for similar infractions. The profession must look inwards and advise itself appropriately. I thank you all.
Thank you. Thank you, past president, eminent lawyer, role model, mentor. I can go on and on. You can agree with me that the choice of Mr. J.B. Daudu SN as a panelist is well made. It is just a harvest of facts and submissions. I cannot even go on to summarize them. I want to thank Mr. J.B. Daudu SN. Thank you for what you've done this few minutes. Please, I can assure the audience that your paper will be available. Your paper will be available. While thanking you, I want to touch some particular bold and courageous comments you have made here today. That even what we're talking about, forum shopping, has different variants. For me, I just learned one variant this evening, and I guess many people would have learned more. The variant I learned is that when security agencies ferry people from one part of Nigeria to Abuja, for example, all arrest, take them to Abuja, that it is also forum shopping. That is classic. It's a new variant. Again, if the superior courts do not frown on forum shopping, the lower courts cannot do better. But those are profound statements, you know, very, very profound. You also mentioned the brazenness with which judges today and lawyers engage in forum shopping and the danger it portends to democracy. Let me go straight to Prince Lateef Fagbemi. Soft-spoken, very articulate, distinguished lawyer. Like I said when I was introducing him, has extensive practice in election petitions. And my Lord Justice Spidel Webinar, when he started, said, these ex parte orders and other forms of injunctions and judgments of the like increase during election periods. And we are just on the threshold of the election periods, and they started already. 2023, what will happen if this trend is not checked now? You've had JBWSN state clearly that corruption is there. Corruption is at the base of this. Corruption is at the base. So let me call on Prince Latifa Wemi. How do we checkmate this? Even as election petitions will come, even as election, pre-election matters will come, how do we checkmate this flying of orders, injunctions, and all the rest? If the bench and the bar are culpable, what should we do? Should we throw our hands to the air and say, all right, that's what's going on? Or what are your prescriptions? Please welcome Prince Latif Fawemi. Thank you, sir.
Well, thank you very much, the organizers, my noble lord, very distinguished senior advocates, and my colleagues listening to us, the audience. I feel greatly privileged to be called upon to come and, be involved in this interactive session. You see, it's like a small child. We all know what is right or what is good. When a small child does anything wrong and you approach, you see the child running away. If there is any issue on which there is total unanimity amongst us, it's about this issue of ex parte. Forget about conflicting. It starts from somewhere. And as a prelude, let me say that in both England, in the United States and in the UK, two professions that are difficult to get into, but very easy to get out, are law and medicine, medical profession. Very difficult to enter, but very easy to be thrown out. That is because not only are these professions regulated, and I want to say that ours is also regulated. It is better to have good laws, bad laws administered by good men than to have good law administered by bad men. Let's identify the stakeholders. Who are the stakeholders here? The litigant, the lawyers, the judiciary. And when I say the judiciary, let me break it into even the chief judge and the judges. Some cases are, like I said, forget about whether ex parte are conflicting. Should you approach the court for ex parte at all in election matter? Looking at the electoral law, the only situation where you can approach the court for an ex parte order is when you want to serve by substituted means. And that is understandable. Otherwise, I cannot perceive, I'm prepared to confess my ignorance, that I do not see any other situation that will warrant you're asking for ex parte order. But let me concede for purposes of argument that, you can approach the court for ex parte. You know, the exhortation in the law report and what we have in the statute, they are so clear that some areas are no-go areas, especially in election matters, whether election or pre-election. In matters, for example, in matters of membership of a political party, you cannot approach the court ex parte, because the court has no jurisdiction. It has been said several times. The issue of locus is also there. Apart from this, we also have the subject matter, this is part of it, the subject matter when it comes to membership of a political party. Then where do you go? This has been flogged. A matter meant for Ibadan, for example, you take it to Abuja. Even where you have authorities to the effect that it can be taken, I think the chief judge also has, the chief judge has the power to say, well, I have looked at it for convenience sake. This is where I think the matter should go. Unless in very extreme cases, there will be no reason for those cases to travel offshore. What I mean by offshore is travel from the base, the place where this issue have arisen. apart from the issue of territorial jurisdiction, you know, a chief judge, before, I don't know the practice at the Federal High Court, or not only Federal High Court, other courts, our cases are assigned. But I would think or expect that before a judge is assigned a particular case, well, the chief judge will know the capability, the strength of his judges. I think this is where we have to be a bit more careful in assigning cases, even though the chief judge cannot on his own say, okay, I'm not going to assign this because it deals with ex parte order. Like I said, the law reports are replete with when to do and when not to ask for any ex parte order of injunction. What are the sanctions? Before discussing the issue of sanction, let me say that, you know, there used to be somebody called Adram 40. Adram 40, we all know, was an election, an analyst when it comes to examining electoral documents. I understand, I wasn't there. There was a time he was asked to give a particular, follow a particular trend in giving evidence when he was invited. His response, well, he's dead now, was, I'm sorry, I can't. They offered him money. We'll give you so much. He said, I can't. Because he knew, according to those who were with him, that if he had done it, before he got home, he would have papers querying him, ready for him. But because they value their names, they value their integrity more than money, there are certain areas they will not venture into. Apart from this one, some, you know, to show that there is really a collusion, if there is any area where both the government and political parties unite in celebrating or hailing the judiciary or showing compliance with court order, is when they obtain this ex parte order, you see them coming out, oh, we are law abiding, we'll make sure that we obey the order. As a way out, because my very good friend, the former president of the bar, JB Daudu, said so many things. I would say that I agree with him, most of the things that he said, not all though. For instance, the issue of what to do or the power of legal practitioner disciplinary committee vis-a-vis the power of legal practitioners privileges committee. You know, when the legal practitioners privileges committee disciplines, it is not to remove the lawyer or punish him because he's a lawyer, even though he's first and foremost a lawyer. It is because he has behaved in a manner that the privilege that is being accorded should be looked into. They are not saying that he's not a lawyer. What they are saying is, look, we gave you this privilege. If you behave in a manner that we believe is incompatible with the status, we can, you know, have you, we can remove the privilege or the honor or have you suspended. I have not misunderstood him. That does not, and they don't have to wait to me for LPDC to do anything, because it doesn't concern the his status as a lawyer. It is his status as a senior advocate, the privilege of his being a senior advocate. Now, in respect of what to do, you know, we must, I want to say that there is a distinction between display of scholarship and display of rascality. Yes, a lawyer has misbehaved. He believes that he has a case. He approaches the court. There are some lines that the court or the judge should not, you know, cross. Then when this issue of ex parte order is, comes to the fore, the NJC, to me, should not wait for any report. Oh, we wait until there's a report. Some situations are so very, you know, they are so serious that I believe, like the one that the Honorable the Chief CJN has done here, they are so, you know, horrible that I think that the NJC should not wait for anybody to complain. Fortunately, the internet, is it Facebook and all the social media, they have made the world, I mean, everything to be like we're in a global village. Something happening in Maiduguri or in Lagos, within minutes, you have or get wind of it. I think those involved should be called immediately, one, for explanation, two, if the CJN is not, the NJC is not, the NJC through the CJN is not satisfied, they should immediately, issue the people concerned with query. Now, the Bar Association, I would suggest that, like the NJC, the Bar Association, well, I know the Bar Association also has what we call a monitoring team. The monitoring team will not be, the duty will not be to witch hunt anybody, but where there is a serious issue that will call for, will excite the bar positively or negatively, they should be able to take it on and call upon the concerned lawyer. Everybody has to man his beat. For the lawyers, it should be, don't wait for any disciplinary committee. Well, disciplinary committee, that is when the litigant complains. It's different. But when you have such a horrible situation as the one we are dealing with, I think the bar should also spring into action. Just like, as I will also suggest that the NJC should also do the same thing. But by and large, you see, all these matters, from the point of view of both the lawyer and, I mean, from the angle of the lawyer and also the judges, put together, the consequence, or let me say, the effect of a fundamental cause. And you cannot deal with the effect in order to cure the cause. We have to look at the way we get people into the profession. You look at the way you appoint people into the onto the bench. I have appeared before a judge in on a matter dealing with garnishi. We know that the only way that by which you can kickstart a garnishi proceeding is via ex parte. That is allowed. Those are statutory exceptions. The judge insisted that I could not come by way of ex parte. But because there were law school students, I didn't want to, after talking, got angry, but still, I had to keep my anger. Minutes after, there was an ex parte order, ex parte motion of injunction, which the court, the judge granted. So I just told myself that, it is not in all cases that some of these judges take money, believe me. At times, it may be, with all respect, a disease of the head. A disease of the heart deals with corruption. It is also there. So we have to talk to ourselves and know where we are going. We know where we are, but is that where we should be? We have to review this issue of appointment. No matter the factors that you put on, we have to be true, be honest with ourselves. The issue of nepotism and allied vices will have to be shown. When a judge gives an order, I repeat, it is not in all cases that money, corruption is involved. It may be as a result of the limit of his own knowledge. So, coming to how to confront the menace, we all know it, but are we ready to do it? The disciplinary committee of the bar, and it is heartwarming to hear the president of the bar give a promise that those involved in this dastardly act will have to be investigated, will have to be interrogated. As lawyers, I don't want to come to any conclusion now, but I know that it is horrible, and it is, when they hear them, then the law will take its course. The You know, another thing is, usually when you approach the court, you say you give an undertaking in damages. I ask myself, who is giving undertaking? What is his strength financially that you want to give undertaking in damages? It is easier said that, oh, we give undertaking in damages. If you want to do that, go and bring your bank draft or bank guarantee that this is what you do before, place it before the court and prepare to give damages. If it is 100 million, 200 million, give it. That does not mean, the impression some people have is that, oh, unless I come in at the stage of ex parte order, I cannot get justice again. No. Cases abound. The decisions of the Supreme Court where those who avoided, where they, at the end of the day, they give decisions or orders that will accord with the need or justice of the case. And in election matters, you know, it doesn't travel beyond, at the most, a year, 4 months. At the most. So I agree with the identification of the issues involved, but we need the will, political and otherwise, to confront this menace. In matters of ex parte order, like I said, I have mentioned the National Judicial Council, the NJC. At the state level, the Judicial Service Commission is also involved. Because if the NJC is overwhelmed, the JSC, the Judicial Service Commission is also there. What role does the NJC play in matters of appointment, for example? It is what you take to them that they ratify. But I would suggest that before judges are appointed, just like when you want to make a senior advocate, for example, you advertise. If you have any objection, you have any comment, any observation, any complaint, please lay it. I would suggest that at the state level, this should also be allowed. It is not enough that we are consulting with the bar. I'm not saying that the bar should not be consulted, but the general public should also be allowed or given the opportunity to make their comments or observations on the people we want to appoint. Then in matters of punishment, as soon as an issue is tabled or an untoward development or situation occurs, we should not wait for a year, 1.5 years, before you let the public know the outcome of your investigation or interrogation, whether for good or for bad. Let the public know so that the impression is not created that, oh, well, there have been complaints, but we don't know when the outcome will be given or will be rendered. It is important that we swing into action almost immediately. We are all involved. We are all stakeholders, the lawyers, the judges, members of the NJC, the members of the public. Like the governor, Aketi, forgive me, has said, politicians will not cease to be politicians. Never, never. It is the lawyers and the judges that will define the limit. There are occasions you render advice against taking a particular course of action. You might lose 10 naira, yes, but when the chips are down, I tell you, the same litigant will come and your take home will be more or maybe more than 50 and 100 naira, speaking from experience. I thank you. This is my little contribution. I agree with most of the things that they have said, and the areas that I have disagreed is one of them is the area of this issue of the line between the legal practitioners disciplinary committee and legal practitioners privileges committee in matters of discipline of senior advocates. Thank you very much.
Thank you, Prince Latifa Wemi. Again, we've gone into harvest of very, very cogent points. Let me proceed from there to our last panelist, Ms. Sophia SM. But before we get there are issues that have been thrown up. We talked about it earlier. The intervention of the CJN. As we saw, Sophia talks about the issues she has come to discuss. How do we look at the intervention of the CJN? Should it be followed going forward? And we got another variant of the problem, the disease of the head and the disease of the heart. So we are going to be having legal cardiologists and legal neurologists for us to be able to cure the disease of the heart and the disease of the head. And there was a point Prince Fabemi made. He said, politicians will not cease to be politicians. And that is true. But it is the bar and the bench that should set the limits. But when people are running after practitioners and even judges romance with these politicians, how will they say no when it gets to the politician saying this is a payback time? How does the appointment of judges, the process, are judges appointed now by merit, or do we have appointments based on political considerations and other clarish considerations? So we will have our last panelist, then we will begin, we will take questions. Please put your questions in the box. We are monitoring the box, and put your comments so that we can go around through the panelists and our lead presenter, and then before we wrap up. Certainly, this has been an engaging session. Mrs. Opia SN Anayo, please, it's your time to make your presentation.
Thank you very much, Mr. Moderator. The indications I was given is to not to look at the controversial aspects of this topic, but because the NBA section on public interest and development law also takes into account the position of the members of the public with regards to issues of ex parte order. I was invited to explain or to give a justification, first of all, for ex parte order, and to look at whether ex parte order per se deny parties their constitutional right to a fair hearing. So it's going to be a sober discussion of what ex parte orders are meant to serve, what purpose they're meant to serve, and whether this purpose in achieving them will contravene parties' constitutional rights to fair hearing. I must say that my Lord Revival, in his overview of the subject, had touched a lot on this. But I will start by saying that, of course, our Constitution provides for fair hearing, and that nobody can have his civil rights decided upon without being given a right to be heard. I'm not preaching this to lawyers, because we lawyers, we know it, but for the interest of the members of the public, there is that provision in the Constitution. And a layman in the street who looks at ex parte orders simply as a process of taking a decision against him behind his back will ask, why then would a court make an ex parte order on an issue? What is the power that a court has to make ex parte orders? To that, I'll answer that practically all the rules of court make provisions for ex parte orders, empowering courts to make ex parte orders in appropriate circumstances. In appropriate circumstances. And for the interest of the public, which the NBA section on public interest law want to cover in this discussion, I would want to also look at these circumstances in some details. Some parts of it have been mentioned by other panelists. Now, the very way in which ex parte applications and orders are structured and the purposes for which they are meant to serve do not intrinsically infringe people's constitutional right to fair hearing. Rather, they are safeguards inbuilt within the rules of court and also guaranteed and explained better in pronouncements established by many judicial authorities to protect every party's right to fair hearing. Authorities are galore on that. Because of this, we find that ex parte orders are usually not declaratory in nature. They are not declaratory in nature because declaratory orders are meant to determine rights against the public at large. Rather, they are usually injunctive orders made for preservation of the subject matter of litigation, so as not to ultimately leave a court in a situation of fait accompli by the time that the court has heard and determined the matter on the merit. As I said, this aspect of this discussion is meant essentially for the interest of laymen. My colleagues at the bar and the judges know this. So I'm not preaching to lawyers or to judges, but I'm speaking more to the members of the public who have some perception of what fair hearing ought to be. So ex parte orders are meant actually to preserve rights, and they are applied only in situation of extreme urgency in order to save the subject matter of a litigation from destruction, from dissipation, or even from total annihilation. These are what the authorities say, and they are correct. For instance, a member of the public that has an issue, say over land, finds is an aggressor on his land, developing the same before he is able to file a suit and serve him and come back with an application or notice for a restraining order, can go for an ex parte order to have the subject matter preserved until the rights of the parties are determined after full hearing. So, and also in that way, the interest of both the applicant and the person against whom the ex parte order is made are preserved until determination of their rights on the merit. Now, because of this, ex parte orders are usually provisional in nature and made typically contingent upon certain events. Most of the time, usually the hearing of an application on notice at which the other party shall be given full opportunity to be heard before a final determination is made. An ex parte order is therefore not an order in perpetuity, but always confined to a short lifespan. By most rules, it's usually 7 days or 14 days maximum, or for as long as it will take to avert the threatened damage to the rest, to the subject matter of litigation, and to determine an application on notice during which the other side will be given the opportunity to be heard. And when that is done, the applicant is not given any undue advantage against the respondent in this case. So members of the public who have become suspicious of ex parte order because of what is happening then need to know that it was essentially an ab initio made for the protection of their rights. Now, a court would not lightly make an order ex parte, except it is satisfied of the existence of a real threat and danger of destruction or dissipation of the rest, the subject matter of litigation, and the urgent need to stave the same in the best interest of justice to the parties, as well as in the public interest. There are authorities that confirm this. So intrinsically, an ex parte order is a process of court deliberately designed to secure and enhance administration of even-handed justice to the parties before a court. So the problem is not, the problem we're facing now that has motivated this discussion is not in ex parte order in itself, but in the manner in which the process is employed. That is what the process, or that's what where the problem is. Like my learned brother has said, that sometimes you have good laws, but bad operators. And when you have good laws and bad operators, the law appears to be bad, when intrinsically, actually, it is not bad. So any use of the application of this process in a manner and for a purpose which produces an effect contrary to the purpose it was meant for is a clear abuse of that process and negates the rule of law. And that is why we're having this discussion, because ex parte applications and ex parte orders have been employed to achieve purposes that are contrary to the rule of law. That's why the NBA steps in, because the NBA is there to uphold the rule of law. And by this exercise, I think the NBA is making a very big statement through its section on public interest and development law in regard to the abuse of ex parte orders. Now, to my mind, one of the questions that were raised also was whether the current problem arising from the use of ex parte orders that have given rise to this discussion have any judicial backing basis, or whether there could be other motivations other than pure law. I would say yes, that the indications are there, very clear. And every discussant here had highlighted it in very different ways. So there's no denying it that we have not kept to the strict rules guiding the grant of ex parte orders. For instance, to shop for an ex parte order from a court which does not have territorial jurisdiction over the subject matter of the case is to procure such an order, and to procure such an order in a manner that negates the rule of law is an abuse of the process that was ordinarily established for good. We're all lawyers. I remember that at some point in time, especially in political cases, which is what is happening now, lawyers would run from maybe Enugu here, where I am, to Abuja, to the Federal High Court Abuja, to file an application ex parte to obtain an order in a pre-election matter. And we'll be running to Abuja to go and hear it. And at the same time, some other lawyer for the same litigant will run to Federal High Court Enugu to obtain a different order. And you have this conflict. So making use of application of ex parte orders or applications ex parte in such a manner definitely is an abuse. And that is what is causing us the present concern for which this seminar has been mounted. And also to apply for or to make by a lawyer or to make an ex parte order by a judge in respect a declaratory and conclusively determining, for instance, the right of an aspirant to contest an election as the flag bearer of his political party clearly negates the constitutional principle of fair hearing and the rule of law, and also negates the purpose for which an ex parte order, because when you have made a declaration that XYZ as against ABC is the right in an election, you have given a determination on the merits. You have given a conclusive determination as to who represents that political party in any particular election. And also to apply for and to make an ex parte decision on a subject matter which lies exclusively within the domestic domain of a political party cannot be said to have any legal basis in view of the litany of authorities that we already have and the electoral law that is in place in the country. So there can be no justification in law for such application or for such an order. One cannot vouch for the integrity of such ex parte applications and such ex parte orders. And there is a strong suggestion of some unwholesome motives which leave an unsavory slur on our justice and political system, and then also which compromise our democracy and its processes. I would say that my own contribution is very brief, and I'll leave it there. But at the same time, I would like to endorse a lot of what the previous contributors have said. I particularly would want to mention the statement by the president of the NBA, which he made on this subject on the 30th of August, 2021, and the recommendations that he has made there. I believe that the present webinar on this topic is a follow-up on that, on the indications given by the president of the bar. So I think that with a better understanding of the purpose of ex parte orders, maybe my learned colleagues at the bar, and then also most respectfully, members of the bench, would review their attitude towards this. We do not lack guidance. We do not lack guidance either by way of statutes or rules of court or decided authorities on the purpose and use to which ex parte orders can be placed. We are just not doing the right thing. And as my learned brother, His Excellency, the governor said, and also my learned friend, J.B. Dowd, my learned brother, St. J.B. Dowd, said, these things have consequences, and lawyers must be wary of allowing themselves to be used for purposes that demean the integrity of the profession, the integrity of members of the bar, and the integrity of the bench. We must be wary of this and do not allow litigants, do not allow our clients to use us for purposes that will leave us in a very shameful and deplorable state in the profession. I thank you. I'll be ready to take other questions on it. Thank you. I said I'll be very brief, and I am. I was told I would spend.
Thank you, my sister. You will see that, you could see that you took the rear. You took the rear and boldly standing your ground, giving a lot of confidence to the ladies in skates that they have a future in this profession. We appreciate you greatly. Thank you.
Thank you.
Mr. Nayo, Josina, Ofia. Thank you, all the panelists. There are several questions that are piled up. I can tell you the interest generated thus far is so overwhelming. We got our capacity of 520, and there's no people who have been calling to join, they can't join. Across the country, across the world, the discussion we're having here is garnering a lot of interest. So let me go back to our panelists
on YouTube Live
and now raise some fundamental questions. June 10, 1993, a judge, Justice Basi Beme, delivered an ex parte order in the evening to stop an election. June 15.
Was already held.
Yes, my lord. June 15, 1993, Justice Saleh delivered another ex parte order to stop the announcing of results of election. The country has not survived the effects of that. Sometime too, a Chief Justice of Nigeria was removed by ex parte order. We still have that with us. And there are several other orders like that. And while we are discussing that, some form of practice direction has come in favor of FIRS, in which case they give you an assessment and the order can be granted to them. Half of your you must deposit half of what assessment they've given you before you can be given a hearing.
It's going nowhere.
If you are given a
Program is going well.
given an assessment, if you are given an assessment of 1 billion, you must deposit 500 million before you start. And that order came ex parte. So I want us to begin to look at all these things. Let me go straight to His Excellency, Arakurin Akeredolesen. You are also, you also have your own Inland Revenue Service in your state, beyond the federal. I've given some scenarios. What's your thought on these issues? Thank you, sir.
Well, thank you. I mean, if you have really hit the nail where you are supposed to do it, and you spoke about the issue of Basi. May God bless our souls. She's gone, and a few other ex parte orders that we have battled with that has caused a lot of imbalance in the country over time. And now, this is a problem of the judiciary. Because I'm not saying ex parte order is a problem of the judiciary, but I'm particular about the issue you raised about that people ex parte order by Inland Revenue, in which you are expected to pay half of whatever assessment that that is given to you. I do not see why you guys should lead to, I mean, give a happy hand to such things. To me, you see, there are several abuses. And as JB Dado has said, and a few others have said, that even we need to look inward. Not only those of us who are legal practitioners, look inward, not only at the lower bench, the appellate and courts. Something must have to be done. We must all come out and say this thing honestly, because there is no other way to put it. There is something fundamentally wrong, and all of us must be prepared to sit down on the round table and look for solution to this. Because what we are discussing, as I said so earlier on, is an abuse of a process. A process that, as Justina has said, is put in place, as my Lord Justice Roosevelt has also alluded to, is put in place for specific purposes. The purpose for which is to be used is right. But because we are abusing it, and because the profession had also been too laid back in finding solution to this abuse, that is the problem. And I mean it, that look, something fundamental has to be done. We hear about judges that are going to go before the NJC. Maybe if something serious is done about it, maybe it could be a signal to others. Maybe if some of our colleagues appear before the Disciplinary Council and something is done about it, just like Lati said that it's hard to get into this profession. We should make it easy for people to leave this profession if they abuse rules of the profession. That I believe can be done. So the issue you have raised, to be specific about, we have our own ODRS, Ondo State Internal Revenue Services. We have it, but in our own case, we also have a law, but we don't have a law that says if they raise charges, you must pay half of it before you can file any action. No, we don't operate by that. But people have challenged our assessment where necessary, and we go back to court, and we have the Ministry of Justice, and we have lawyers over there in the ODRS who will be there to at least take up the case clearly. And at the end of the day, whatever you arrive at, even if you arrive at the fact that somebody, because of our process that allows for delay, if at the end of the day, it's a year after that you are found to be liable to pay what we have assessed, we'll take it. There's nobody, the government is not going to die, neither are you going to die. So I don't see why you have a process in which asks you to pay half of the assessment before you're hired. I totally disagree with that.
Thank you, our past president. Thank you, our very senior colleague. Beyond what you have just said, Your Excellency, let me look in the direction of Justice Roosevelt, a shining star, a distinguished jurist at the Supreme Court until retirement. Even at retirement, still a distinguished jurist. My Lord Justice Roosevelt, the Supreme Court, that you were a shining star continuously for several years. In 1995, delivered 2 judgments, 7-Up and Abiola Bottling Company, and the provisional liquidator of Tap Industries Limited and Onyekwelu. These judgments followed the English case of Thomas and Bullock, that ex parte orders are not, do not contravene the fair hearing requirements of the Constitution. And many people have continued to ask, that even God asked Adam and Eve, where are you, to hear them? With what is happening with ex parte orders that have brought us to this webinar, my Lord, do you think going forward that our justice system should continue to retain the reasoning in Abiola and 7-Up, or should the court begin to look outside the window, jettison it, amend it, panabit it, or do something else? Thank you, my Lord.
Hello, can I be heard? Am I heard?
Yes, sir, we can hear you.
Yes, sir. My Lord, you are loud and clear.
Ex parte orders should never be removed from our rules. Ex parte orders are very, very good. It is only when you have rascals sitting on the bench that you start seeing all these type of things we are seeing. Look, earlier on, you gave an example of when the Abiola election was stopped by an ex parte order. Then everything went haywire. We have inbuilt mechanisms in the judicial system to correct that mistake made by that Justice Bassett. That the next day they could have gone before the Court of Appeal and it would have been corrected. But we just make the judge gave this ex parte order. It confused everything. Everybody threw their hands up. Everybody started to what can be done. The judiciary is corrupt. The judiciary has the inbuilt mechanism to correct their judges who don't know their left from their right. If they're anyone, if they are there. You see, ex parte orders, as I said at the beginning of my paper, I gave guidelines for the grant of ex parte orders. There are very, very important orders that are given to last for a very short time. So when they are given, they should not cause any problem to the other party who has not been heard. As you said about God in the Garden of Eden, it is true. The Lord saw what Adam and Eve were doing, but he still gave them a hearing. You see, we have to look at this. Look, take examples of ex parte orders. If the government wants to demolish your house next week and you go to court this week, you should be granted an ex parte order. If there's a general election next week and you go to court this week asking for an ex parte order because you are denied participation in the election that is holding next week, and you give an ex parte order, that judge must have his head examined. What is he giving the ex parte order for? You have to weigh the interests of the person asking for it and what damage it will cause to the greater majority of the society. When you have all these very important cases that things could go wrong and very easily, a judge, what he saw, should hear the case day to day. Day to day. That's how it's done. So when you ex parte orders have been there for time immemorial. There's nothing happening now, as far as I'm concerned, that has not happened before. That was what a short panel was all about. That was all what Justice Uwais was doing as chairman of the NJC immediately after the short panel. Several judges were removed for indiscriminate grant of ex parte injunctions. It was only from about 2010 to about a year ago that there was a lull in checking these indiscriminate orders. But they were there, they were done. That is why the title of what we are discussing today, the resurgence of ex parte orders, appears to be very apt, because there is a resurgence. And I said this resurgence always comes up when there is election. No other time. It is when there is election you see it. That is when. But we make I don't know, either retraining or training for judges, especially trial judges, to be very careful and be well guided in granting of ex parte injunctions, and not just grant it indiscriminately or how they choose to, because it can cause serious damage if it is not looked at properly. And where a judge grants an ex parte injunction indiscriminately, it should be reported to the NJC. But in that case, should go before the Court of Appeal the next day. And the Court of Appeal should put everything aside and correct it. Thank you. Do you hear me?
Thank you, my Lord. Thank you, my Lord. That's erudition. As we begin to wind down, let me ask the past president of the bar, Mr. J.B. Dadu, there are reactions that I'm seeing that these issues of ex parte orders actually affect men and women of timber and caliber, for whatever that means. And that is why it happens and nobody does anything. And we also hear people saying there's no database. So how does a lawyer know, how does a judge know whether there are conflicting orders? And a distinguished senior practitioner in this country, George Etomi, recall that Arakuri Akredo Lesen has said that politicians will do anything, but it's up to us to stop them. How do we stop the politicians? If we can't stop them, how does the practitioner continue to practice? He has a juicy brief. His economy is not good. I want us to reduce it to practicals. The lawyer doesn't have money, or enough money at that point, But the politician is saying he's going to roll out so much money. It becomes a temptation to the practitioner. Your viewers are asking, mostly lawyers, what's your prescription?
You see, temptations of any nature are meant to be overcome. There are some that will, of course, swallow up the person to whom the temptation has been shown, but by and large, it's a matter of choice. If you choose to fall for the temptation, then you must be ready for the consequences. So there is a balance. The danger really is beyond how you have put it. It's not a bread and butter issue. It is that it tears into the fabric of the society, because you can use ex parte orders to enthrone injustice. And injustice leads to self-help. And self-help leads at times to jungle justice. Now, people feel more comfortable going to the courts to get even-handed justice. And most times, when people get justice, they don't complain. They don't even go on appeal. But where you have a situation that the last bus stop of the common man is manipulated in favor of a stronger or a richer or a more powerful person or powerful politician, then you find that people might take their recourse or redress to some other ways. Now the lawyer or the legal practitioner has a choice. He has a choice whether to follow his professional ethics or to play to the politicians or the rich man's gallery. Our own duty, if he does not behave himself, is to ensure that we show him the way out of the profession. Now, I can tell you, a lot of people will opt to remain, to eat the small crumbs that fall on their table, than to have a large chunk of meat and then be shown the way out, together with all the disgrace and disrepute that follows. So if we do not quickly show the way out to erring lawyers and judges, these issues will consume us. Mind you, it's not only in political cases that you have abuse of ex parte orders. It is used also to oppress between a rich litigant in land cases and the poor one, to oppress the poor client. So it becomes a tool of oppression in the hands of those who are well practiced in employing such divisive tools. So that, I think, is my short answer to the posers of raised, that no one is duty bound to follow the rumblings of his hungry stomach when his conscience is another thing. That's my answer.
Thank you, past President. Do you think that, just before I leave you, because in my place, when you see an eagle, there's a mandatory requirement that you should get the feather, because the feather of an eagle is not seen every time. Yes, you have said that well. How do we trickle what you have said down to the law, to the legal practitioner that was called a few weeks ago, so that he understands this properly? And what shocks absorber do we have in MBA that can help such legal practitioner to start firm and say, no, I will not take this brief, and I will not go hungry. The profession is there for me. Thank you.
You see, it is not really a matter of welfare. It's like we used to have a very respected legal practitioner those days before he passed on, a matter of conscience. Now, to get the young lawyer to appreciate wrong from right, and as I said in another forum last week, it has to be ingrained in his legal education. We need to have in the curricula of the universities issues of ethics taken from first semester in his first year up to the last year. Should be a continuing program, so that the impression the young lawyer gets between the university and the law school is that legal practice is where you can cut corners, where you can make money quickly. It's a money-making minting machine. And if you are smart, you will get by. No, it is not. You will get by if you are honorable. You may appear to go hungry at the beginning, but it gets to a point whereby you will not suffer. So that is a way out of it. Apart from the issues that the NBA is doing, it's continuing legal education. I see particularly one of the things I must credit the Akpata presidency for is that he has built up a solid continuing legal education platform. And of course, he's right to do so, because you have a pool of young lawyers that need to be taken through the rudiments of this profession and the justice system within a very short period of time. He cannot do more than that. He has to teach, and is teaching junior lawyers how to fish. Giving them fish at times, not bad, but they may get the wrong signals. So therefore, I think that the real emphasis should be on legal education and the realities of sanctions that will accompany anybody that decides to follow his own heart. So that's my answer to your question.
Thank you very much, sir. As we continue now winding down, let me now go to Prince Latif Fagbemi.
Oh, before you go to Fagbemi, can you take something from me?
Yes, sir. Please go ahead, sir.
It's just an intervention to endorse what JB Dadu has said. And I think we have been on this for long. But you are a professor, and maybe you have to contact your other colleagues. We have to at least design, as you call it in university, a course properly that will teach ethics in the university. We don't have to wait until we get to law school. So as JB has said, this has been the contention over time. Look, if you design a course that can run for 3-4 years, and at the end of the day, you must pass. And you must also show that you understand it. I can assure you, many people that are getting to law school would have inculcated part of the necessary ethics. Now, we started with dressing. The number of our universities today, everybody wear white, black suit and tie to class. It's part of it. But the essential ethics of the profession we need to teach it in our universities. A course must be designed for that, and on which you have to earn some points before you graduate. I think it's important.
Thank you very much, sir. Thank you. We are indeed blessed with great past presidents of the bar coming into way. That even what you are doing today is also part of inculcating the ethics, because thousands of lawyers are hooked on as you speak, listening to you at the height you got to, and seeing that you're saying that it's encouraging. And let me go to Prince Fagbemi. How do we cage the politician, the businessman, the professional consultant, the consultant that links the corruption link with the judges, with lawyers, and other. How do we cage those consultants that do all those evil and immoral acts? How do we cage the politician? How do we cage the businessman that say it is money that it will take? In this country, we hear people say, what money cannot do, more money can do. So how can we cage such people, and so that they can leave our profession for us to run as a sane organization and association? Principal Baby.
Well, I don't know, that's a tough one. How to catch them?
Is he muted?
Technical support.
Yeah,
Technical
me too.
support.
No.
I
Can
think
you hear me now?
you were hearing
Can
you
you
now.
hear me now?
Yeah, we are hearing
Yes,
you.
yes, sir.
Yes. Now, as far as I'm concerned, if you approach me, get an expert or whatever, if like my noble Lord Honorable Revival has just said, it is not in all cases that you say you will not go for expertise. It depends. But where you believe, like in this situation, that it is going to be horrible, it is going to be devastating, it is against your conscience, it is very easy. I am sorry, I cannot do it. And I can count how many, well, so many that I have turned down. That is as far as I'm concerned. But before I do that, what I do, and I let people know, is if you come to me, you will pay for consultation. If you pay me my consultation and I advise you on the strength of your case, I'm okay. If you want to take my advice, it's fine. If you don't want to take my advice, it is also okay. I do my own, but how to go and approach, or like I said, when an order is obtained and you see politicians rushing to say we will enforce it. No, they won't say they enforce it. They'll say they will obey it because it's a court order. Then you know there's something. From there, you can take up both the judge, the lawyer. But if you take it from the point of, from the angle of the lawyer, then there will be no. He doesn't see it as, oh, this is the market. I want to. I'm satisfied. And you punish the erring litigant and also the judge. Like I said, some orders are so horrible, and forget about cross-border jurisdiction. Some have always crossed the line of, oh, this is a no-go area. This man has no local standard. Even though you are not to hear the other side at the stage of granting or considering that order, but there are some of the major cardinal factors that you take into consideration. If you go against it, then something is wrong. Then we have to sharpen our disciplinary arsenals to deal with the situation. Thank you.
Thank you very much. And then finally to Mrs. Justina Ofia SN. How do you see any role for one, technology in helping us navigate through this process? Do you see any role for the legislator? Two questions. Do you see any role for technology for the legislature as we wind down? Do you see any role, Mrs. Wan? Thank you.
Yes, just to get to that, I want to add something to what my learned brother said, Sagbemi had just said in respect of the last question, just briefly. I personally don't think that it is our responsibility to start chasing after professionals, businessmen, and consultants in order to rein them in. It is within us. When we cure ourselves of the ill that has been bred within our ranks, then others will learn that they should not take such briefs to lawyers, which they find tempting. If I say no, and my learned brother 6 says no, and the other person says no to the temptation, then all these business people will learn to know that lawyers say no to corrupt applications and corrupt orders, and it will stop, or at least it will be checked. Now to the issue of whether there's a role of technology in all this. Yes, definitely. The world is now functioning based on various technological appliances, technological apps, and so on. And the legal profession and its business cannot be left out of it. But the thing is that we need to train our members to be able to capture the use of technology. Technology is there. Something happens today here, in 1 minute, it is all over the world. Everybody now in all parts of the world, people calling from all parts of the world say, aha, I hear what is happening in your country. So now they are selling ex parte orders. So we can't rule out technology. It's there. Information travels far and wide, and we need to be conscious of it. We also need to embrace the use of technology in the practice of law in all aspects. We are talking about virtual hearing. It is technology. We are talking about e-filing of processes. We are talking about e-payments. We are talking about all manner of electronic gadgets in the practice of law and in court proceedings. It's all technology. So we cannot rule it out. And my position, as I always taken it, is that some of us, I remember when my class, we had our 40th anniversary. In Abuja, the keynote address we had was the role of technology in practice of law, something like that. And we were scared. Personally, I was amazed at the extent to which technology had taken root in the practice of law in other jurisdictions. And we're just starting here, more or less starting here. So it is indeed important that we begin to embrace it, especially people of our generation that did not start the use of technology in primary school or secondary school. We have to learn it and embrace it, because otherwise we cannot move on with the times in law practice or in anything, actually, in anything in the society now. The world has been made one global village by technology, and we must key into that new world order. Except we do that, we'll not be able to go ahead. I don't know if I captured all your questions, but if I didn't, please let me know. Thank you.
Just to thank all the panelists, but I will have a giveaway question and see if there's anybody that will just 1 minute. It is better to have good judges determine a bad law than bad judges determine a good law. It is better to have good judges determine a bad law than bad judges determine a good law. In view of all we have discussed, does any of the panelists want to, 1 minute, just pass a comment on it? Do you agree?
Enjoy an answer. I think our best solution is to have good laws and good judges and good lawyers also. That's my take.
Thank you.
But if we happen to have bad laws, then it will be good to have good judges managing bad laws. But my take is good law, good judges, and good lawyers. Thank you.
Well, I agree with Ophia. Justina, I think she's right. She has said it all. But let me just weigh in on this. We have not. Did you conclude about this Federal High Court jurisdiction, Paul?
My lord, sir.
No.
Yes.
Your lord, okay, I'm not your lord.
Yes. Yes. The point.
Jurisdiction must.
Yes.
Have you concluded on it that we must restrict it at all costs, whatever it was?
I agree entirely with you, my lord. I was even saying, my lord will see that from 1983, Wema Bank and Bronick Motors, till now,
You cited those cases.
We are still talking about jurisdiction of Federal High Court. It's a shame. It's not acceptable. Even though there is only one Federal High Court. That's the Supreme Court decision in Milatankori. That is the Milatankori case. That you cannot go to Borno or to sue in a matter that is locally in Lagos.
That's what is happening.
That is Milatankori's case.
That's what is happening.
So it is not that those doing it do not know that it is wrong. It is impunity. That's my view. It is total impunity because it happens and nobody does anything. And that's what we are discussing.
All right. Thank you.
Yes,
Thank you so much.
Thank you, Your Excellency, my President.
Okay.
Thank you, my Lord Justice Rosvivo. Thank you, Justin Ofia SAN. Thank you,
JB
Daudu SAN. And thank you, Prince Latifa from SAN. Thank you. I've enjoyed speaking with you, going through this difficult terrain with you. Thanking you for your time. I pray that this country will be better and become a nation where peace and justice shall reign. I will now yield the mic or the platform to Mondo Nekachobani for closing prayer.
Thank you. Thank you. Thank you, Prof. I really appreciate your moderation of this program. You brought a lot of fun into it and a lot of intellectual input into it. I want to thank Milord. Specifically, Milord gave me an assignment when I got him online in order to participate in this program. He said, Mr. Bani, we have decided on this issue of ex parte and conflicting ex parte all a long time. Go and write an article on it. And I've actually taken up that challenge. I will do that by next week. It should be published because there are many revelations from that assignment that have been given. Your Excellency, I didn't know you will have time for us for this. We know how busy. But I also saw that you were conducting some of the business of the state, even while you were participating in this program. Thank you. Thank you very much. Having known how busy you are, but I really appreciate. Yes. No, you were doing that. Were at the background. We saw all the gesticulation and all that. But honestly, we are highly, highly honored to have your presence in this program. That again speaks a lot about you. You said it. You won't contest any other thing. You are coming back to the bar, and you have really shown to the entire world that you are a barman indeed. Very, very grateful for this. I want to thank our JB Daudu, the former president. Honestly, when I got him online, he was the first person and he consented. He never in any way said, oh, Mr. Bani, I won't be available. He said, I'm going to make out time in order to participate. And we really enjoyed all the intellectual input that he made in this. Of course, Prince Latif, he made so many suggestions on what we should do concerning this topic. And I must tell you that we are looking at all those suggestions because the president of the bar, he's in this program and he has stayed throughout. That again is wonderful about the personality of our president. I call him the people's president. And I believe that he has listened to all the suggestions that we're going to put all this into most of the things we're going to do with regards to our colleagues, who have actually not put this profession in a proper manner. And I also want to thank Our Lady, the Amazon. Your intellectual input in this particular discussion was something else. We really enjoy. And of course, you can see the flurry of comments from the participants. Everyone said good things about all the panelists, starting from my Lord and then the former president, the two presidents, and my governor, and every other person that really, really said everything that we needed to say concerning this particular matter that is of public interest. Now, having listened to all this, we are going back home to really look at what we should do, both at the bar and bench. What will the bar now do with regards to what has happened so far in order to act as a deterrent? What will the bench do? All of us have a role to play if you really have to save this profession. Now, for all those who listen to this program, please, we are coming up next week with the payment platform for you to join to be a member of Spidel. Spidel is the fastest growing section in this particular MBA. We want you to be a member, and that platform we made available so that you can join to be a member. Know you that this particular program is on YouTube. We are going to distribute you to all the lawyers platform for those who couldn't participate, because we are getting called that they were not able to log in because of the number of limitations. The man told me he's going to take up 1,000, but I found out that he could take only 500 plus. He couldn't take up to that 1,000. But there are those who joined on YouTube, when he was streaming live. We are going to make it available for all our lawyers in order to listen to this highly intellectual discourse on this matter of public interest. We really want to serve this profession, and we have a role to play in doing this. So, Mr. Moderator, I must say thank you, and I want to thank all the panelists. I want to thank my Lord, and I want to thank the Amazon. I want to thank all the legal colossus who participated in this program. All our colleagues, learned senior advocates. There are many judges who also told me they will join there, and I saw some of them there. And the learned six, most of them, Mr. Ajibade, you are so many that joined in this particular program tonight. We appreciate you. Now, I want to say a prayer. Father, thank you for all you have done. As we go, Father, go with us. Take all the glory, for your glory no man will ever share. In Jesus' name we pray. Thank you. Thank you. And so I want to say thank you for participating. Thank you for participating. We'll ensure that all of you will have this particular YouTube live on all the legal platforms that we have in Nigeria. Thank you, and God bless you. Now,